About to hear is not just another legal scandal. This is the moment when the justice system turned inward and exposed something far more dangerous than corruption itself. Corruption hiding behind the law. This was the exact morning a federal courtroom crossed a line no one ever expects to see crossed. Judge Caldwell did not raise his voice. He did not threaten sanctions. He did not ask for arguments. Instead, he did something so rare that veteran court reporters say they may never witness it again in their careers. He ordered the arrest of the defense. And it happened on live television. To understand why, we need to rewind to the moment everything broke open. Just before 8 a.m. Eastern Time, an encrypted audio file appeared online. It surfaced simultaneously across multiple whistleblower platforms. Not leaked to one outlet, not quietly shared, but released in a way that made containment impossible. The label alone was chilling. Witness 14, privileged, do not distribute. Within minutes, legal analysts knew something was wrong. Within an hour, millions of people had downloaded the file. Within 90 minutes, every major news network was playing segments of the same recording. This was not rumor. This was not speculation. This was evidence. The voice on the tape belonged to Witness 14, the prosecution's most protected witness in a high-stakes federal corruption trial. A witness whose identity was sealed, a witness whose safety had been guarded by federal marshals, a witness whose testimony was expected to decide the case. But the recording did not capture the witness alone. It captured the people who were supposed to be following the law. The audio runs just under 12 minutes, but its impact may last decades. 3 voices are clearly heard. Prosecutors have since confirmed their identities: the lead defense attorney, a senior associate, and a third individual acting as an intermediary tied to the defendant's business network. From the opening seconds, it becomes clear this is not a casual conversation. This is pressure. Early in the recording, the lead attorney explains that the witness must understand that cooperation carries consequences, not legal consequences, personal ones. The wording is deliberate. The message is unmistakable. This is not defense strategy. This is intimidation. Minutes later, the intermediary confirms that the witness's family situation has been addressed. Employment, education, relatives, daily life. Every line tightens the noose. Then the conversation turns to money. Payment structures, consulting entities, offshore routing, retainers designed to leave no fingerprints. Since this morning, subpoenas have confirmed wire transfers totaling hundreds of thousands of dollars that match the dates referenced on the tape. The timing is exact. The trail is real. By the time court convened, prosecutors already had forensic confirmation. Audio analysts authenticated the voices. Metadata confirmed the recording date. The device was not planted by law enforcement. It came from inside the defense team's own orbit. Court filings now suggest a junior staff member with access to the defense office had been cooperating quietly for weeks. Federal agents reviewed the recording shortly after it was made, but delayed arrests to expand the investigation. Then the leak happened, and everything accelerated. When Judge Caldwell took the bench that morning, he had just received a sealed filing. Observers say he reviewed it silently for less than 2 minutes. His expression changed. His posture stiffened. Then he looked up. "Marshals." That was all he said. The courtroom froze. Officers moved immediately toward the defense table. One attorney stood up to object and was cut off mid-sentence. Another remained seated, pale. A third visibly trembled. The judge's words next are already being replayed across the country. He stated that he had reviewed evidence of criminal conspiracy, obstruction of justice, and witness tampering committed by officers of the court. He said their voices were no longer welcome in his courtroom. Within 3 minutes, all 3 attorneys were in handcuffs. The defendant they had been representing sat alone. This was not just dramatic, it was historic. Legal experts say arrests of defense attorneys during an active trial are almost unheard of. When they do occur, they usually follow lengthy sealed proceedings, not a public order from the bench. This case began months earlier as a textbook corruption prosecution. A powerful real estate developer accused of bribing officials, manipulating zoning decisions, and funneling money through shell companies. Witness 14 was the centerpiece, and former executive who flipped, an insider with documents, a witness who knew where the bodies were buried. As the trial progressed, the defense grew increasingly aggressive. Motions to expose the witness's identity, attempts to undermine protection orders, what prosecutors later described as a pattern of harassment aimed at government witnesses. Judge Caldwell warned them. Now we know why. According to legal analysts, the language on the tape suggests not a momentary lapse in judgment, but a coordinated system. References to other teams handling other situations imply a broader operation. That detail matters, because if prosecutors can establish a pattern, this case could expand into a full conspiracy investigation, possibly even racketeering, and the consequences ripple outward. The trial itself is now in chaos. A mistrial is under consideration. Any new defense counsel inherits a poisoned record. Every prior strategy, every conversation, every filing may be tainted. Attorney-client privilege, the cornerstone of defense law, may no longer apply. Experts explain why. Privilege does not protect crime. When attorneys become participants rather than advocates, their communications become evidence. For the defendant, this is catastrophic. For the legal system, it is alarming. Witness protection protocols are now being reevaluated nationwide. Emergency relocation has already begun for individuals connected to Witness 14. Federal marshals are treating the threat as ongoing. Meanwhile, bar associations have launched emergency proceedings. Disbarment appears inevitable. Civil lawsuits are expected. Entire careers may vanish overnight. Public statements from attorneys representing the arrested lawyers have attempted to frame the situation as misunderstood or politically motivated, but analysts say those arguments collapse under the weight of authenticated audio and financial records. Context does not erase threats. Structure does not excuse intimidation. This moment has forced the legal profession to confront a terrifying question. What happens when the people sworn to protect justice exploited instead? Defense attorneys exist to safeguard rights. Without them, the system fails. But when that power is weaponized, the damage is far worse than any single crime. Trust erodes. Witnesses stay silent. Justice breaks. Right now, 3 attorneys remain in custody awaiting arraignment. The trial they were defending is suspended. Investigators are expanding their search. Additional charges are expected. And the nation is watching. Because this isn't just about one case. It isn't just about one judge. It isn't just about one recording. It's about whether the law applies equally, even to those who stand inside the courtroom wearing suits instead of handcuffs. The next few days will decide everything, and whatever happens next will be remembered for decades. This is not the end of the story. It is the beginning of the reckoning.